Hello, IP friends. It's been a minute. So, if you're yet to listen to my last episode where I talked about when to issue a cease and desist letter in the event where your work has been infringed upon, talking about the Haribo and the alcoholic gummy bear case, please listen to the last episode. And if this is your first time listening to me talk about intellectual property related matters from copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication, please click the follow button or subscribe or favorite button on any of the platforms you're currently listening to me. And for my returning listeners, actually, I can't count for you guys for sticking with me, my IP friends, sharing the gospel, retreating, sharing whatever. I mean, I appreciate you guys. Thank you guys for always coming back to listen to me. Now, I'm just going to digress a bit. I don't know how many of you are following the hashtag Iranian women case taking place currently, where an Islamic woman was beaten and she eventually died because she wasn't properly wearing her hijab. I know it's symbolic to the Muslims and part of their religion, but this has caused a lot of outrage and protests within the last 2 days. People are calling for a total ban of the hijab wearing. But yeah, let's lend our voices. The protest is about the killing of a 22-year-old Mahsa Amini over hijab. Women are taking off their headscarf and burning it. I watched a couple of videos last night. They are trying to normalize forced hijab as a cultural dress code. So hashtag Mahsa Amini is trending currently. You also see hashtag Iranian women. So yeah, you guys should check that up. And then for my Nigerians, please, let's obey. Prepare to get your voters card. But yeah, thank you guys for coming back to listen to me. Let's get into our conversation for today. This is another throwback edition, and I will be talking about trade secrets. And this is actually a Nigerian case which I stumbled upon sometime in 2019. So I featured it during my end of year Christmas edition. I have the next edition is coming out this year. I think this is the 4th edition. But yeah, I think I'm talking to let's just get into our conversation for today and get right into it. So our case study for today is centered about a type of intellectual property mechanism that kind of gives the owners some sort of edge in the market. And this is a Nigerian case, to be precise. So I stumbled upon it when I saw a post by Dr. Chijoke Okorie. She is one of the writers for IP Cat, which is one of my favorite intellectual property blogs. You guys should check that out as well. And I was like, okay, I think this is a good conversation. And I think that day too, in the World Intellectual Property Organization had posted something on Twitter about how Coca-Cola and Google company own some of the world's most valuable trade secrets. And I was like, okay, let's delve into this. So this case basically was like a contractual breach involving the misuse of intellectual property-based confidential information. Now, this is the type of IP, like I said, that is called trade secret or confidential information, depending on the jurisdiction and how businesses, can commercialize and exploit it, especially within Nigeria, where we take a lot of things for granted here. So the case is Chams Plc and another against Mastercard Asia Pacific PLC Limited and 5 others. Now, sometime in 2006, the federal government opened a bidding for the national ID projects, which Chams Plc emerged as the winner. Now, Chams Plc was incorporated as Chams Consortium Limited into the implementation of the national ID concession through a special purpose vehicle and invited Mastercard to work with them. So they kind of went into like a partnership with Mastercard. And Mastercard was like their technical partner, and then they signed an MOU with Mastercard Asia Pacific PLC Limited. And on the 18th of November 2002, 12, that's 6 years later, they entered into a customer business agreement with Mastercard, which included a non-disclosure and a non-compete clause. That's like, I mean, when someone puts that in, it shows you that person means business. But welcome to Nigeria. Not like I'm bad mouthing Nigeria. I mean, people basically globally, internationally, contracts are breached every day. But I think Nigeria is like a special breed where we like to sign contracts and not, take them very seriously. But again, just my own personal view. So what is a non-disclosure clause? So when you see non-disclosure clause, what does it basically entail? It means basically that you are not to share any sensitive or confidential information that will be shared with you to a third party. So the disclosing party is the owner of the information. The receiving party is the person receiving the information. And it is your duty that you keep it a secret and do not share it without the knowledge of the disclosing party, or do not even steal it. Now, this would have been like a mutual or one-sided non-disclosure clause, but that doesn't seem to be the case. While a non-compete clause, it's considered to be that you're not going to compete. So basically, it's also known as covenant not to compete, because you as the receiving party or the contracting party, you're prevented from competing with the disclosing party in a similar business or trade. Now, the advantages of having a non-disclosure clause is that the information gives you an edge. It prevents any form of intellectual property theft or infringement. It also builds trust between parties, and information shared cannot be used for malicious purpose. And the penalty for breaking that will also be stated in the agreement. So damage in form of loss or profit or criminal charge, as the case may be. Now back to the case, you will understand why these clauses were included in the technical partnership arrangement between Mastercard and Chams. Now, Mastercard played a fast one. Turns out that they played a fast one on Chams Plc, and by going to collide with the National Identity Management Commission, who operates and regulates matters of national identity in Nigeria. That's your NIM number that is being made compulsory for everyone right now. It also serves covering national identity number, enrollment and insurance, national EID card insurance, identity verification, as well as data harmonization and authentication. Now, NIMC, that's the National Identity Management Commission, was a client to Chams. And Mastercard, after being provided with a copy of their exclusive and confidential concession agreement, and they had knowledge of the architectural design, so they had information to things that were not in the public domain. They had access to the architectural design of the national ID project designed by Chams, the functionalities and other confidential information that we received from Chams. And turns out that it was also Chams that introduced Mastercard to NIMC as a technical partner under the concession agreement. Now they will go ahead to go and start having meetings with NIMC without informing Chams or the consortium who brought them into the contract, and eventually Mastercard entered into an agreement with NIMC. This is worse than what Judas actually did to Jesus, because like you see this happening a lot, which is why sometimes in your agreement you kind of put clauses that protects you as the disclosing party or the partnership that kind of brought the deal. When Chams found out about it, they were not happy, trust me. And as at 2019, there was a 114 billion naira suit filed against Mastercard. Now, the breakdown of the suit is that 84 billion are special damages for anticipated loss of the revenue from the project, 10 billion as general damages for fraud, and 20 billion from inducement of breach and termination of the concession awarded by NIMC I'm currently not aware that there's been a judgment given in that matter, but I will find out about that and disclose to you guys before the end of this podcast. But if I don't do that, please send me a voice note. Also, you guys should check out the Coca-Cola suit that took place this year in the US. I did a newsletter talking about that case, so you can also check that out to learn more about obligations, to learn more about employees' obligation when dealing with confidential information. So the difference between the Coca-Cola case and this Chams case is that in the Coca-Cola case, the chemist, that is Ziarong Yu, was a chemist and former employee of Coca-Cola Atlanta and Eastman in Kingsport, Tennessee branch in the United States, and worked for them for 5 years. Now she was sentenced to 14 years in prison by a federal judge in the United States on grounds of conspiring to commit economic espionage and for the stealing of confidential information related to the formulation for bisphenol A free coating for the inside of drink cans said to belong to a major chemical and coating company such as AkzoNobel, BASF, Dow Chemical, PPG, Toyo Chemical, Sherwin-Williams, and Eastman. Now, BPA was a chemist or is a chemical used to maintain certain plastics and resins to preserve flavors, which is valued at $120 million and was said to have been stolen for a Chinese company called Weian Jinhong Group, backed by the Chinese government Tusan Talent Program, which recruits leading experts in research and innovation, according to several news online. Now, going back to our Chams case, you see that Mastercard actually went into a crash. So they're not like employees; they're more or less like independent contractors, and decided to sideline and go into, like, they wanted to get the deal directly from the organization awarding it. Now, for a business, trade secret is any information that is not generally known to the public or your competition in the business, which they might make an effort to actually keep it a secret. For instance, the famous Coca-Cola recipe, KFC chicken recipe, and other recipes, other confidential types of confidential information out there. Now, this information can either bring or confer economic benefit to the owners. It gives you selling point as well. It's not generally known and promotes standards. Trade secret cases often include related claims such as claims for breach of contract, which we've seen in the case between Chams and Mastercard, breach of an employment agreement against a departing employee, unfair business practices, and or a violation of a non-competition provision, that is the non-compete clause, which I earlier talked about. Now, what are the types of information that can qualify as a trade secret? First, you have formulas, patterns, and in this case of Chams Plc against Mastercard, it was the architectural design of the National ID project, its functionalities, a list of key customers, product specification, list of reliable or special suppliers. Whereas in the case of Ziarong Yu and Coca-Cola, it was the bisphenol AB, that's the BPA chemical used to make certain plastic and resins that preserves flavor. So other types will include technical information such as industrial processes and recipes not made public by carrying on the business, a detailed information about the day-to-day operation of an existing business. For instance, market research data, detailed costing, and business information about new projects or business ventures that must be kept a secret until it is launched. Now, what qualifies as a trade secret? First, when the information shared was done while imposing an obligation of confidence, as in our case between Chams and Mastercard, and the Coca-Cola case against their wrong due where the unauthorized use or disclosure could cause harm to the company owner or party sharing the information, as we've seen. In the Chams case, Mastercard was giving certain information about how the ID project was going to go, and they just, went behind the back of Chams to go directly to NIMC rather, National Identity Management, to get the project. And then when the quality of the receiver must exist, which would not be vague or be in the public domain knowledge or trivial in nature. So that's about that for what qualifies as a trade secret. Now, after knowing what qualifies as trade secret, it's very important that business owners should pay attention to the things that help their brands and companies by having proper documentation and ensuring that the relevant clauses are always put in place. But Chams did that, and they still got slide and played by Mastercard, who went ahead to discuss with the National Identity Management Commission, NIMC. However, the other options available to the owner of a trade secret. Now, the trade secret owner must put in place a system of identifying what information may hurt their business, make a list of information that deserves to be protected. They must have a good data security by developing a security policy, assign specific staffs to keep and record information, educate all employees on the importance of keeping the information a secret and making sure that they actually understand that, dude, this is a secret and you need to keep it a secret. You need to also be thorough while hiring, always do background checks. It may be a bit difficult doing background checks in Nigeria, but then, making calls to the referees, asking, former employers for recommendation or questions about your employee will also help as background check. I know there are instances where sometimes, so if you're applying for like foreign jobs, sometimes you see those places where they ask you, are we allowed to do background checks on you? Can we, reach out to the security agencies to find out if you've committed any crime, XYZ. And for employees who have left, let them be aware that they still have an obligation to their former employers. We saw in the case between Sierra Wrongview and Coca-Cola, she still had that obligation with her former employer. Then they also need to maintain company secrecy at the end of the day. Did you know that trade secret protection is also automatic like copyright, as long as it is kept a secret and meets the basic qualification of what can be a trade secret? The protection of confidential information is automatic. What are the benefits of having like a confidential information? It doesn't involve any form of registration cost, like you're not paying anyone to register your trade secrets. It has immediate effect, it does not require disclosure. There's also no limitation as to the term of protection or duration. For instance, where you have copyrighted materials such as musical work, literary works, 50 years to 70 years, etc. Sound recordings, 50 years. Trademark, 7 years, renewable for another 7 years and another 7 years. And, depending on your brand strategy, you can keep, extending the life of your trademark. Patent, 20 years. Design rights as well. Plant variety as well. They all have their own term of duration for protection. So with trade secrets, brands like Coca-Cola have been in existence for more than 50 years. And then I would also talk about issues that relate to right to privacy and personal data, which I feel I felt that Mastercard had violated that data or information that was given to them that they should have kept confidential, but they never did. Now, the moment Chams Plc and its consortium gave their consent to Mastercard to access their information, they were bound to keep that information private, but rather they misused and broke the trust, and therefore they violated the privacy of the contract and its term. And in this case, Trade secret is the private information, that is the architectural design of the national ID design. Chams Plc and its consortium also gave consent to Mastercard to access the information shared, which was misused and trust was broken. They also had privy to the collector of the information, as disclosure could also affect the interests of the persons involved, as was the case here. Now, if you look, so I had posted a picture of the suit. So a suit number FHC LCS 140 2019. So the plaintiffs basically are Chams Plc and Chams Consortium Limited against Mastercard Asia Pacific Pte Ltd, Mastercard Services Sub-Saharan Limited, National Identity Management Commission, Mr. Aja Banga, Daniel Monei, and Omokedi Ojomuyide. Apologies. Then there was an ex parte for other respondents such as Access Bank, Citibank, Coronation, Merchant Bank, Eco Bank Nigeria, Fidelity Bank Nigeria, First Bank of Nigeria, First City Monument Bank, FSDH Merchant Bank, Heritage Bank, Keystone Bank, Nova Merchant Bank, Polaris Bank, Providus Bank, Stanbic IBTC Bank Nigeria Limited, Standard Chartered Bank Limited, Sterling Bank PLC, SunTrust Bank Nigeria Limited, Union Bank of Nigeria PLC, and oh god, finally, United Bank for Africa PLC. Now, in this digital economy, data is not only valuable, but it is vulnerable because of the digital protection system. Customers' information is gold to banks, not to talk of businesses, as it is commercially valuable and useful for marketing plans and policy. Now, I've done a poll there and I asked, do you think customers' data can be classified as trade secret or a personal data? 85% said yes, thankfully. 50% said maybe, and I wonder why. Like, you don't think your customer data qualifies as trade secret? I mean, anyone who has access to that can monetize this, like, do you get? Then I also asked, right to privacy is enshrined in our constitution, seen in section 37 of the 1999 constitution and other international laws. Do you think privacy is a priority for businesses in Nigeria? 67% said yes, and I agree. Like, with the loan apps and the rest of that, you see that your privacy is not even taken serious. We also had issues with Truecaller at some point. Don't know if that has been resolved. But then those issues were there. 33% said no, privacy is not an issue. Even I think recently I got a message from what's that company? I think Shutter something, and I don't recall ever signing up for Shutter. So I was wondering where. So I kind of wondered, like, where did people get my information from? So sometimes you go for an event and people are like, oh, put down your name, we're going to send you messages and XYZ. So sometimes what I do is I just put my name, I don't put my personal details, other personal details like phone numbers, my phone number or email. Do you get it? Because you haven't really told me what you're doing with my information. So I put down my name, yeah. What happens when I leave the event? There's no, when you ask questions like, oh, it's just to follow up. You get my point. So privacy is something that we don't really take serious, and I think it's very important that businesses start taking note of. So we have a data protection regulation in Nigeria. Read it. You have a website, you have an app. What are your policy terms there? Are you registered with NISDA? Are you doing the needful? Are you sharing informations of your consumers or customers or clients with third parties? All those issues are there, which is why it's very important that you have a lawyer. Either you have a privacy lawyer, a data protection lawyer, or an information technology lawyer on your team, or an IP lawyer, just depending. But don't have a generalist lawyer that, basically get a specialist lawyer that understands that particular field. So if it's a tax related, you should get a tax lawyer. If it's a labor, you should get a labor lawyer. If it's a what's this now? I'm trying to give different examples, but you shall get my point of what I'm trying to say. Now, I'm also going to digress a bit and talk about the Coca-Cola case. Now, I have a question now. Can you impose a secret or confidential information on an employee? Now, that depends on a number of things, such as did they arise when they signed the contract? If it did, then it might be implied that the employer considered that the employee, is capable of handling that information that has been shared with you, and then they understand the duty of fidelity imposed on them as an employee due to the nature of their job. What would now be the thin line? What would you now say, oh, this is an employee skill or is experience or know-how and trade secret? Know-how, experience, and employee skills are separated from the person, that is the employee in question, and they're not considered to be a trade secret or confidential information. However, some companies take further steps to make sure that employees with critical knowledge sign a non-compete or a non-disclosure agreement as a condition for employment to keep them from working for a rival or misappropriating the information or setting up similar businesses with the sole purpose of preventing unfair competition. I also think when you're going into partnership as well, you should also take that step with the person you're going into partnership with, making sure that they understand the implications of you having a non-compete and a non-disclosure agreement, to keep them from trying to take the brief away from you, as we saw in Chams' case. Now, is this act reasonable? Yes, if the employer or the person in question was selective as to who he decides to bestow the quality of information to be shared, and if the employee has been exposed to such confidential information belonging to the company, just like in our case study, it is only reasonable that you honor the terms of agreement and duration when you signed as either a partner or an employee. But you can see that Mastercard never did any of that. So did wrong you. So we're still talking about the privacy issues, privacy-related issues, information dissemination, misuse of trade secrets, breach of confidential information, which is basically when a data or private information has been disclosed to a third party without the data owner's consent, who in this case was Chams Plc. Now, Mastercard's offense included greed. Now, where can it be said that the trade secret has been misappropriated? When a party uses or discloses the trade secret on breach of a contractual obligation to maintain the trade secret, as done by Mastercard, who went behind Chams Plc and the consortium to sign an agreement with NIMC. Unfair acquisition of trade secret through theft, fraud, or other dishonest acts, using or disclosing the information even after learning of its unlawful acquisition by another person. Now, how can a trade secret be stolen? One is through industrial espionage, such as corporate spying, access to code. How can a business protect its trade secrets? Generally, there are no specific laws for trade secret protection. However, there are relevant provisions of the law that one can rely on, and they include law of torts by court actions and appropriate clauses in an agreement in accordance with the law of the contract, using a non-disclosure agreement or confidentiality clause or a non-compete clause. You have unfair competition. We have a competition law in Nigeria, and so does every other jurisdiction. You have criminal law, which is like the invasion of privacy, etc. Now, a trade secret is violated once there has been an infringement by one person who basically hopes to gain competitive advantage and misuse the information, like Chams did and what Ziarong did in the case between her and her former employer, Coca-Cola. How can a company or a brand market confidential information? One, by making sure that there are limited persons who have assets, limited persons who are qualified in the company to access that information, and it should be handled to prevent misappropriation. So you mark it confidential. It can also be locked with a password or an encrypted file that only those privileged to access it will input the required password. You can also create like a data room with limited access, and then make no copies. What are the defenses against an allegation of trade secrets misappropriation? One, if a claimant or intellectual property owner makes an allegation, such as one that Chams is making against Mastercard or Coca-Cola against Ziarong, once the claimant or intellectual property owner makes an allegation, they can show that there was some sort of misappropriation or the information was stolen and it meets the trademark qualification, the accused person must show that it was a public information or that they used that information and they had no insight of Chams invention as at the definition of what a trade secret, as also the definition of what a trade secret to be was ambiguous in the contract that was signed. Then the intellectual property owner, who is Chams or Coca-Cola in this case, failed to do the needful in protecting um, the architectural design and the functionalities, or the BPA. For instance, um, NIMC or Ziaron's former employee, instruct Ziaron former employer that um sorry, to instruct the former employer Ziaron that she had the duty of fidelity and confidentiality, and she was not authorized to share such information with a third party or anyone who was not a staff of Coca-Cola. Same thing with Mastercard. They should have instructed them not to share information with third parties that are not staffs of Chams or its consortium. In the absence of an agreement, it can also be considered that it was implied because of the relationship they go in. So it could be the employer, employee, or the partnership they were going into. The person also needs to show the type of intellectual property mechanism that is important, to also understand the thin line between secrecy and being specific on valuable information. Also, in the Chams case, there was a motion of notice filed and the following prayers as the following request was made, that Mastercard be restrained from printing any national ID with NIMC logo. Remember that trademark protects names, words, logos, slogans, colors, figures, etc. that are distinctive in nature. They're also asking that the court restrain the Nigerian banks that I listed, the 19 Nigerian banks that I had earlier listed, from honoring Mastercard's transaction with the use of a national ID card. Then an until-pillar order for seizure and custom machines for printing the cards and the seizure of the cards themselves. For the police to arrest anyone who obstructs the execution of the court's order. So when I did this tweet, I actually attached copies of the order, which was dated 8th of November 2019. Now, remember I talked about Anton Pillar. So Anton Pillar basically is like an order of court that requires that a defendant or respondent to allow a certain person to enter their premises, to be able to search for documents and movable articles, and it is also specified in the. So this is given without notice to the other party. So it's called an ex parte. So you just come in like, here, this is the court order and we are going to do XYZ, blah 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 blah. So you're not pre-informed like a motion or notice where you're put on notice before you come, so you're already aware. So you're not even going to be aware. And it is a remedy available in the Nigerian jurisprudence as it relates to intellectual property dispute. Other remedies include the court order restraining the person or company from further misuse of that confidential information, monetary compensation in form of damages, which will be paid on actual loss caused by Mastercard's Act or Ziaron's Act. So I think, let me go back to Ziaron's case. And I think Ziaron's case, other than the 14 years, was she asked to pay any money? I don't think she was. Okay, yeah, she was. She was sentenced to 3 years of supervised release and just a $200,000 fine. But she wasn't asked to pay Coca-Cola anything. But the chemical she had stolen or alleged to have been stolen was valued at $120 million. Yeah, and that's a lot of money, guys, if you look at it from the business perspective. I mean, if you get $120 million today, what are you going to actually do with it? That's how much one person took. So moving on, seizure order has already prayed and ordered by my Lord Honorable Justice R.M. Aikawa. Also, the agreement to always understand. It's very important that you understand the terms. Pay close attention to non-disclosure clauses and non-compete clauses whenever you see them in your contracts. Know that trade secret is not free for disclosure, and every agreement parties should ensure that there's a dispute resolution clause which has to be multi-tiered. So basically what that means is instead of opting for just mediation or litigation, you have what is called a timed um mode of resolving your dispute. So you are going to negotiate for a couple of days, say 7 days. If that fails, you mediate for say 21 days. If that fails away, you go to arbitration, or and arbitration is considered to be legally to be binding on all parties. If you don't want that as well, the court should be like your last option. But because we need precedents in Nigeria, people should go to court too. But I would still advise for out of court settlement. It's quicker, it saves relationships, all the good stuff you can think about. That's what the alternative dispute resolution mechanism can offer you. In this case of Chams against Mastercard, they had made effort to resolve the case by reaching out to Mastercard through their lawyer, but the big brand wasn't ready to settle amicably, but rather they offered Chams Plc and its consortium $500,000 as opposed to the $100 million that they asked for. Sorry, they offered 500,000 and Chams was asking for $100 million. Oh boy, the money big. I'm not gonna lie. Now I feel that NIMC they should have verified the information when Mastercard kept coming along. They're like, "Oh, have you informed Chams?" But no comments on that. But let me just focus on my cases so I don't get into trouble. But yeah, knowing fully well that they were earlier introduced to Mastercard by Chams as their technical partners, they should have verified the title to the information, and also the confidentiality procedure should have been followed. Luckily, finally, we eventually had, at 2019, there was no IP policy and strategy in place, but was it last week? Yeah, this week, we had like some sort of public hearing for or last week. Yeah, this week rather, 13th. When was 13th? 13th last week. I'm kind of confused, but we recently held like a public hearing for the Nigerian IP policy and strategy. Documents were shared. I also shared it on my LinkedIn page, so if you want to download a copy of it, you can go through it. We didn't have one before, now we have one, but then it's still in the review stage. I'm sure they will update it because there were comments and feedback that they got during the public events presentation that they had, 3 days event that took place. It was Monday to Thursday. So yeah, it was last week. Monday to Thursday, yeah. The fact that we also don't have a specialized courts, IP courts, even though the Federal High Court hears all IP related issues, I think we still need like a specialized court with specialized IP judges. More IP sensitization and awareness, which is what I'm currently doing, advocating for more IP awareness. And I'm glad that people are beginning to get more interest. I know I recently saw an IP insurance webinar. I attended one today about sports merchandising licensing. There's another one by the USPTU in collaboration with the Nigerian Copyright Commission for songwriters that's coming up in a couple of days. So there are several activities upcoming. I'm also having I'm having like 2 this week already. One on Telegram, having a radio presentation on Cool FM on Thursday by 5 p.m. So if you're listening to this and you're in Port Harcourt or Rivers, please tune into Cool FM by 5 p.m. I have a conversation for creatives. We also need everyone to understand the value of their creativity and innovation. Know that intellectual property touches everything. I mean, it's time we start to think big, when it comes to intellectual property. What are the challenges that you might actually face when you're challenges and limitations you might face while trying to enforce your trade secret? I will start by saying that one of the advantages for businesses as MSMEs, businesses and intellectual property owners, is that there's no time limit as to, time of duration. I already mentioned that there are no fees to pay, there's no need to disclose information. Now, the challenges will be on enforcement. So you see that Chams, as at 2019, made some requests. Pretty sure they had issues enforcing all of that. Then there's also trade secret allows reverse engineering. There's also limited means of protection, which is extended to non-disclosure of confidential information. There's also the illegal and unfair acquisition of information, like we saw in the Chams case against Mastercard, and also Xeron's use case against Coca-Cola. How is trade secret access? So this can happen with the help of an internal theft, as we've seen in our case study for today, or Mastercard had access to Chams information and decided to, misappropriate it, use it, misuse it, and went to sign an agreement with NIMC. See how wrong decided to sell it to a Chinese talent company, to make extra bucks or through external threat. I already talked about remedies. You can sue, you can trigger your privacy and data protection policy if you have one in your company. The stolen information can also be destroyed on court order. Now, to wrap this conversation up, I will be giving a few what my recommendation is going forward as relates to trade secrets and what businesses should know and how you can protect yourself. If you have more information about the Chams case, please let me know. I will always update what I've posted. So yeah, let's get into our recommendation and wrap up this conversation for trade secret for today. But I do hope that business owners or colleagues or law students or organizations, employees, staffs who listen to this episode, find it really beneficial. So before I get into that, I just kind of did like a quick Google search to get updates about the Chams case. Apparently, there's been no update since the last. Going forward, guys, train your employees on trade secrets policies for the company. Implement a process to keep the information of a secret and include a non-disclosure, non-compete clause in your employment agreement, while including a defense provision where only authorized persons in the company are subject to confidential obligations. In the event of an intellectual property theft of the company's confidential information, tell your story first, then protect the information during litigation. You get. Create an employee friendly trade secret regime in your business. So that's about it from my end on trade secret. If you have deeds about this case, please let me know, guys. So IP friends, if you had a spell time with me today, I did have a spell time. It wasn't easy combining two cases, but yeah, I had a spell time, just briefly analyzing both cases and talking about trade secret as an intellectual property mechanism for businesses. So yeah, if you learned something in this episode, please let me know. Send me a voice note. I would really appreciate it. Or send me a lovely note via my email at ipseriesinfo@gmail.com. Thank you to everyone who has sent me emails, encourages, short notes, tags. I really appreciate you guys. And we're still on our journey to the 100th episode. Don't forget, guys. Subscribe, like, share. Love you and see you in the next episode. Have a fantastic day, guys. Bye.